And right out the gate, the judge is on wardrobe patrol. Think about it. This isn't traffic court, it's felony court. Showing up in a joke t-shirt, that's like walking into a job interview with pajama pants. Not a great first impression.
Did you understand it? Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review court admonishments with your attorney? Did you understand it and sign it?
Yes, ma'am.
You're charged with theft of property, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments. Okay.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confirm?
Quick legal insight here. This means the prosecution handed over all evidence to the defense. No surprises, no gotcha moments later. Judges always put this on record so appeals don't get messy down the line.
Any witnesses, the state would call on the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. So, again, what is wrong with you? Why are you taking a vehicle that doesn't belong to you? Why are you smoking in marijuana in a vehicle that doesn't belong to you? Why are you painting over her rims a vehicle that doesn't belong to you?
I can't say but I don't have no excuses for anything. I can't. I don't do that and like nothing like that. I know I was going through a lot during that time and that's not the type of person.
Well,
I know I made a mistake. I did.
no, that's not a mistake. You made choices.
Yes. I can't.
So if you're drug tested today, what are the results going to be? And you will get drug tested today.
I won't be.
All right. So see, you just told me you're not this person anymore, but here you are standing before me positive.
Marijuana, I smoked marijuana. I do not have people.
Yeah. And you did it in this lady's car. And when she got her car back, it reeked of marijuana and her rims were painted. So you're.
Boom. This is where the judge drops the hammer. Notice how she shifts from legal formalities to raw, personal questioning. This isn't just about stolen property. It's about character, responsibility, and life choices. And she's not letting Amanda wriggle out with excuses.
You're telling me that I'm really not that person. You are, because you're still doing the same thing other than, as far as I know, because no cases have been presented before me, you're still smoking marijuana and you probably smell like marijuana. And the reason why I allowed you to be here at 10 today instead of at 9 is because your attorney told me you had a child to drop off at school. So you dropping off a child at school smelling like marijuana, and I guarantee you that child's clothes smells like marijuana.
No.
That's not who you are.
No.
All right.
Whatever I do on my own, I don't even bring that to her.
Mm-hmm. So let me break it down a little bit. Let me unpack some luggage. So what you're telling me is you go somewhere else and smoke marijuana.
I do it occasionally.
Well, no.
I don't.
You don't smoke it at your home where she is. So your home does not smell like marijuana at all. And then when you smoke it somewhere else, you take your time wherever you are or go to a hotel, take a bath, do your laundry so that you don't come home.
Oof, that's the mic drop moment. The defendant says she's changed, but the drug test says otherwise. And here's the hook for you watching. Do you think people deserve a second chance when the evidence says they haven't really changed? Let me know.
Smelling like marijuana. That's what you're telling me. Yeah. So, see, because let me just tell you, I don't smoke cigarettes, right? Never done drugs, I've never done marijuana, right? But what I can tell you, anybody who comes in, I can smell cigarette smoke on them. You can chew all the spearmint gum you want, then you just smell like spearmint gum and cigarette smoke. I don't drink. Why I don't drink? I just don't think it tastes good. It tastes nasty to me. Anybody who walks up in here and they've had an alcoholic beverages, they can spray their mouth, they can swish some mouthwash. Guess what? I still smell alcohol because I don't do alcohol. I don't do cigarette smoke. I can just, my sense of smell is highly elevated. I guarantee you, your child goes to school, other children who don't have parents who don't smell of marijuana, you know what ends up happening? She smells of marijuana. Children are probably teasing her because her mom smells like marijuana. Now, should children be teasing her? No. But hey, parents teach their children what they teach their children. And you're not making it any easier for her. So does anybody know the restitution for this lady's vehicle? Because it seems as though she had to have them do a detail. I don't know about the rims because she spray painted the rims. Why? I don't know. So do we have restitution amount?
Not yet, Your Honor. We reached out on 8/13 and we're pending the follow-up call.
All right. So I found that there was sufficient evidence to find you guilty. I've deferred finding of guilt, but we're recalling this in 30 days. Will you have a restitution amount?
We should, yes, Your Honor.
We're going to recall this in 30 days with the restitution amount. And what I can tell you, based upon my limited knowledge on the cost of rims, because I have scratched a rim before, and based upon this vehicle, you should be prepared to pay at least, or have with you, when you come to court in 30 days, at least $2,500. That's what happens when you steal a vehicle. And detailing, depending on whether, if she went to go get it.
And now the judge goes for the jugular. She pulls the kid into the picture. This is courtroom strategy 101. When defendants won't own up to hurting themselves, remind them who else they're dragging down. It's harsh, but it hits home.
Detail, depending on where she went to get it detailed, you're looking at a minimum of $850. This is just based upon my experience. Ms. Ferguson, can I have a 30-day reset for restitution? All right, we're coming back on September 22nd. And between now and then, you need to come back here negative. You understand? All right, once you sign the reset form, you will be excused. And counsel, if they have a witness for restitution, the complainant, if she can only appear by Zoom, are you okay with her appearing by Zoom?
Yes.
All right, so if your witness needs to appear by Zoom, she can appear by Zoom,
Yes,
but please have documentation.
Yes, Your Honor. Thank
All
you.
right, thank you. Thank you.
Translation time. This is deferred adjudication. Basically, Amanda's guilty, but the court is pressing pause. If she cleans up, pays restitution, and stays out of trouble,